Hello, and welcome to Disputed. I'm Ted Brook.
And I'm Erin Brown.
Today, we are talking about trials and how to win them.
And joining us today are Tiffany Davies, who is a senior associate based in our Toronto office. Tiffany has a diverse disputes practice encompassing a broad range of complex commercial and civil litigation matters, including sensitive investigations. Stephen Taylor is a litigation partner based in our Toronto office. He practices complex commercial litigation with a special focus on technology and infrastructure disputes. Welcome, Tiffany. Welcome, Stephen.
Hello, thanks so much for having us today.
Yeah, great to have you both on the podcast. Okay, Ted, do you want to lay out what we're going to talk about today?
Well, hopefully, Erin, you and I aren't going to talk about much because we have the pros here. And what we want to do is sort of just sponge up all of the best tips, advice from Stephen and Tiffany about how their trials work, how they win their trials for their clients. Because in my practice, at least, doing a lot of class action work, trials don't happen very often, right? Maybe like once a year, I'm pulled into a trial. And so Stephen and Tiffany, I don't know, do you think that the trial and the sort of the way that it differs from other types of hearings, do you think that this is becoming a lost art? Or are you guys seeing trials frequently enough that it's just me who's missing out?
So from my perspective, there's sort of trials, and I know we don't have video, but then there's sort of air quote trials. And so
you just did the air quote sign, yeah, for our listeners.
Exactly. And so the trial proper, especially, and when people think of trials, they may be thinking of jury trials, what you're watching on the TV with the jury of your peers there deciding it. I think in civil litigation, jury trials are almost effectively a lost art. They're not non-existent, but they're so rare as to be basically non-existent. Then you have obviously the trial in front of a judge, which is still quite uncommon, but far, far more common than your jury trial. And then you have sort of the alternatives to trial, things that look a lot like trial, but are not quite trial. You have arbitration hearings. You have, I practice a lot of construction disputes. So you have combined dispute board hearings, those kinds of issues. And then in my special situations world, I'm dealing with a lot of applications and hearings that way, or summary judgment applications and motions. So if you include those, there's a lot of different ways you're getting in front of a judge for a determination on the merits, but certainly trial propers, I think, are, if not few and far between, not as common as some of the other forms of resolution I see.
Stephen, I think one of the most shocking things that you just said is that, can you confirm for me that practicing as a lawyer is in fact not what it looks like on TV?
I know it's...
Our lives are not like Suits, which I think was probably jarring to listeners. No, I kid.
Tiffany, before we get into your advice, because both of you do have that sort of valued trial experience, what do you think makes a trial different than other types of hearings, whether it's an application, an appeal, or a tribunal hearing?
There's a lot of things that are similar, right? And you're going to have your witnesses, you have the decision maker who's making the decision, but there's just something special about getting into a courtroom, robing up. There's a formality to it. Judges they're going to be more strictly applying the rules of evidence. There's a likelihood of an appeal, possibility of an appeal, right? So it's a bit of a different dynamic. Like you're standing up, you're walking up to a lectern, you're addressing a judge. It's very formal. The witnesses are up on a stand. It feels significant in a way that's different. And I think that impacts your advocacy. You have to practice and you have to advocate in a slightly different way. And I think your witnesses also, they feel that too, and you have to prepare them for that. There's something very different about sitting on a witness stand next to a judge than there is being in your living room over a Zoom call.
Okay, let's let's get to it, guys. So you have 10 tips for us. Stephen, starting with you, what is number one? What is your number one tip?
So number one tip, and I do it not just sort of in random order, but I think this is the most important tip from my perspective. And it's that preparation is absolutely critical. Preparation. And actually goes to one of the points when we were talking at the outset of some of the differences between sort of a trial and other forms of decision making. When you have live witnesses there in front of a judge, you need to be able to go in there with an expectation of what your witnesses are going to say, what the witnesses on the other side are going to say, being able to box in and be ready for anything that might come up. Because it's much, much less controlled than in other circumstances where you have the materials ready. You might have affidavit witnesses. You might have examinations out of court. And therefore, you have that feature of control. At a trial, you have less of that because you're going in, you have live witnesses, and you can always get potential curveballs. And preparation is one of the key ways of dealing with that. So I'm sure people are aware, but trial, to get your evidence in, you're going to have examinations in chief. So your witnesses are going to go up. You're going to be asking them questions. They're going to be telling their side of the story. You're never going to go into that cold. You're always going to have sat through sessions with your witness. They're going to know the questions you're going to ask. You're going to know the answers they're going to give. It's on a script. Nobody's memorized it, but you shouldn't be asking questions that come as a surprise to your witness. And you shouldn't be getting answers from your witness that is a surprise to you. That all of that should be known to you. Cross-examination, obviously, you're not going to have the same level of preparation control with the witness because you might get some answers that are somewhat of a surprise to you. But one of our rules that we use is that when you're cross-examining somebody, you should know what their answer is going to be. And the way that you know what their answer is going to be is because you have some sort of document in the record, something from discovery that you can refer it back to. So if they try and come out of left field, give you something new, you have something to tether their answer to. And preparation is really the key to getting good evidence from both your witnesses and from the witnesses of the opposing side.
Oh, I totally agree. I think preparation is the most important thing ever. I had a mentor of mine once said, you always want to go into trial being better prepared than the other side, right? Like you're going to outwork them, you're going to outsmart them, and you're going to know the record better than they do. And I think that that's really, really important. And so I always think just really spending time with your documents, really knowing the chronology of events, putting together a chronology, organizing the materials, having things at your fingertips, having team members who know the record inside and out so that when a witness says something on the stand that's incorrect or you have the document there to impeach them right away. Like you want to go in there and feel like you have the power. to Stephen's point, there's lots of things outside of your control, but the one thing you can control is how prepared you are. And the more prepared you are, the more control you'll feel that you have. So it's really like, it's a win-win situation.
I think this really harkens back to something, Ted, we talked about in one of our season 3 episodes about sort of junior lawyers or sort of more junior litigators, and something that can really give them an edge up over even a really, really senior litigator is the knowledge that they have, like an incredible handle on the record, the documents, the evidence, probably even more so than that really senior person who hasn't maybe spent as much time preparing or has maybe had more team members involved to it. I think it's also a way to maybe lessen the gap between over like an experience gap between you and opposing counsel potentially, and just make you feel more comfortable and better able to tackle the case. So great tip.
So just for my benefit, because I love analogies that stretch the comparison, if an appeal or a motion hearing is like a meal, right? You're like prepared a meal and then you show up and you serve it to the judge and you're like, does mine taste better than the other side's? Then a trial is kind of like you're making the meal live in front of the judge.
Some sort of like live baking show analogy here.
It's like
somewhere.
a live baking show. I've been watching a lot of live baking show with my wife's mother.
We can tell.
So that's why it's on my mind. And so I could see in that context, if you guys accept that analogy, I could see why you have to do a lot of prep work before. You got to chop your vegetables. You got to figure out your recipe because you're doing everything live, right? Rather than over the course of maybe months or weeks.
It's like when you're watching one of those cooking shows and they're like, okay, and now we'll add the cheese, and they come up with the perfectly prepared, cheese pre-grated in a beautiful, like, gorgeous serving dish. When you're making it in your kitchen, you're going to be like grating the cheese live. So to prepare for trial, just put your cheese in a fancy dish.
Do you guys accept that? I mean, I don't want to leave that with our listeners if you're like, no, that's a terrible analogy.
Ted, stop watching baking shows.
No, I hear you on the end. Sort of, I've watched a few of those as well. And it seems like there's two kind of styles, right? One where they give you all the ingredients, you're there and you go, which is more like the appeal and the motion. And one where they have the pantry in the back and you sort of got to pick out everything for it. So a trial's more like that, where you're sort of, it's not just you're making it, you're actually, you're quote unquote doing the shopping or whatever it is back in the pantry, picking everything that's going to go in.
You might even be like growing your own vegetables in the backyard.
It's theatrical, right? There's a theater to it. And it's not like a Shakespeare play where every word is planned and it's a script, right? It's not like improv either, where you're just getting up there and winging it. It's kind of a mixture of both. So you need to sort of have your script, but you need to be able to adjust, right? Like someone throws you that curveball. They're like, oh, and here's the secret ingredient. It's like guava. You're like, okay, what am I going to do with that? Yeah. So that's like, because you're going to have those curveballs and you need to be agile and ready to respond. Yeah. I think that's a good analogy. Okay. I'll take it.
So, although I don't know, I feel like you threw a competing analogy of like a theatrical performance in there on TED. So let's see how the analogy holds to the rest of the tips. Okay. So tip number 1, prepare, prepare, prepare. Tiffany, what is tip number 2?
So this is tip number 2. It's a form of preparing, is check your productions. Before trial, you need to make sure that you've produced all of the documents that you need that are relevant. Not just because you have an obligation to do that, but you need to make sure you've produced everything you need to prove your case. And this might sound obvious, but I have been in a trial where the other side did not do that, and unfortunately was unable to prove a component of their case. And you don't want to be the lawyer that's in that situation. And I think document production, the discovery phase of litigation, it's most of our clients' least favorite part of litigation. It's the part that requires your client to be, aside from when we get to the trial itself, but leading up to the trial is the part that involves the client the most. Like they have to do the work, they have to go back, they have to dig through their records, and they don't always want to do that, or they might not want to produce a document because maybe it has business information that they don't want to share, and they feel why do I have to give this to the other side? Is this even relevant? And it's your job as the lawyer to say, actually, it is relevant. It's important. And if you notice that key documents are missing, if you need to prove damages and you don't have those documents, you need to push your client and say, look, like I know you have these records. I need you to go and look for them. And if you don't have them, we're going to have a bit of a problem, right? So just make sure you do that. Just make sure that you have the evidence that you need to prove your case, because you don't want to be that lawyer who's in that sticky situation.
Excellent. Yeah. No, it's a good reminder. Steve, any thoughts on that, or do you want to move to the third tip?
Yeah, I'd add to that, which is, and Tiffany made the point at the end there, having the evidence that you need to prove your case, going through that and saying sort of, what are the propositions I'm trying to prove? What are the components? What I have that goes to each of these components, and how am I going to prove it? So on the topic of productions, is this something that I'm going to have as a business record? And if it's going to be a business record, making sure that you're following the rules under the Evidence Act, giving the appropriate notice. There's just a bunch of traps for the unwary. And so having sort of a checklist there that you're dealing with in terms of productions, answers to undertakings, business records, so that you know exactly how you're going through and proving your case and using those productions.
Excellent. Okay. So what's number 3? What is your third tip?
Yeah. Tip number 3, preparation. I might seem a cop out.
That's tip number 1.
Hey, that's not a tip.
It's tip number 1, but it's tip number 3 too. And I don't say this just as emphasis, but it's actually another component of preparation, because there's the trial preparation you do just in the lead up, being ready to prove your case. But preparation for trial actually starts long before that. And you have to be thinking of that as a lawyer, where when you're going into discoveries, you're preparing for that. You're giving answers to undertaking. You're doing your affidavit of documents. All of that is actually a form of trial preparation. When you're doing post-discovery transcript summaries, all of those things usually are happening, in fact, years before trial ever even starts. It might be that you're in a case and it ultimately never goes to trial, but taking those steps at the time that they're happening and thinking of them as a form of not just sort of a step in the proceeding, but as actually a form of trial preparation is critical to being prepared to prove your case when you finally get to trial.
So I think if we're taking Ted's baking or cooking show example, I think this is the sort of like you're planting the seeds for the basil that you need to grow next year so that you can then chop it and put it in the pantry and have it ready. It's like those early phases of preparing years in advance when you're really thinking strategically about like those long lead items and the strategy for how that's going to go into your final product.
Yeah, if we're going further and further down the analogy route, but I'm still there with you.
Yeah, we always try and push it as far as we can, but sometimes that means tipping over into the deep end. I think the listeners are still with us, but it's not just enough to prepare. You also have to prepare. But so Tiffany, can you give me a concrete example of something that a client may not necessarily think is included in trial prep, right? Let's make this a little more tangible for people.
Yeah, I think Steve gave a couple of good examples, but examinations for discovery, that's an obvious one, I think, right? Examinations are about learning and discovering your case, right? That's one of the main goals, is to try to figure out what the other side's case is and what evidence you need to prove your case, right? But you're also working on sort of you could be building part of your trial record, right? So part of those discovery transcripts might be read into the record at trial, right? You might be trying to elicit admissions from the other side that you can use at trial. The other side is going to be trying to do the same thing for your client. So examinations for discovery can happen well in advance of trial, but it's something that actually could be trial evidence. So, that's an obvious example that comes to mind.
Yeah, identifying that, thinking about it, obtaining it, and then doing your sort of summaries and so on and so forth.
Okay, so tip 3 is even more preparation. So, Tiffany, what is tip 4?
Guess what? It's another kind of preparation.
Okay.
So, give your witnesses the time they need. So, this really has to do with witness prep, which we talked about and touched on earlier. Steve kind of touched on this when he was talking about the preparation the first time around. But it really can't be understated how important it is to have your witnesses prepared, because trials are all about the witnesses. The witnesses are the vehicle through which your evidence gets before the judge. And if your witnesses are not prepared, then your evidence is not going to go in the way that you want it to. You might not even get the evidence in that you want before the judge. So you really need to make sure that your witnesses are prepared. And witness preparation is time consuming. It's not uncommon for witnesses to push back and say, like, I think I'm ready. I'm good. Like, I know this. I don't want to do this anymore. They've lived the facts a lot of the time, and they feel like, this is my life. I can answer these questions. But it's one thing to know the story, and it's another thing to be able to tell it, right? And so, for instance, direct examination, We know that you have to be asking open-ended questions. And it's actually really hard to do an effective direct examination and to have your witness tell their story in a coherent and chronological or effective way when you're just asking them open-ended questions. So you need to prepare the witness for that. You need to practice asking them those questions. Go through your direct examination with them. You get an answer back and try to help them understand what evidence you were trying to elicit with your question. You might need to modify your questions to try to get the evidence you want. And then you need to prepare them for cross as well. And that's a totally different experience. And so I always think it's a really good idea to do a couple practice cross exams with your witnesses. Maybe bring in another lawyer from the firm, someone they're not familiar with, someone who's going to maybe make them uncomfortable or has a different style than you, just to get them prepared for the stress of cross-examination. And then also just make sure your witnesses know the evidence, right? Like, so many people think they know the facts, but our memories are not great. Like, that's the reality of being human. And so make sure that you spend time going over, if you're going to ask your witness about a document, make sure they've read it. Make sure that they know what the document says. Make sure that they know what the sticky points are and that they've practiced responding to them. Like, you don't want your witness to be on the stand and be surprised and feel like that they're underprepared. That's the worst thing ever, is to have a witness walk away from testifying feeling like you didn't prepare them. You don't want that. So preparation.
Stephen, in your years of practice, have you seen the effects of a lack of preparation of witnesses? Like, do you have any anecdotes of times or where you've thought, okay, that witness was really not prepared and it is seriously hurt that party's case?
I mean, not in any cases I've advanced, but certainly I've seen it on the other side from time to time, where things like the witness clearly hadn't reviewed, for example, their own discovery evidence before the trial. And they get asked questions and it's sort of 2 years later, and now they're giving completely different answers. And then on cross-examination, it just looks off. And I don't even think the witnesses are intentionally lying or deceiving, but it almost makes it look like they are, because it's, you said X today. Well, let's look what you said on discovery. Something completely different. And once or twice, you can explain around it. But if you're able to do it 4, 5, 6 times with a witness, it just, their credibility is shot and their testimony is useless.
And when you talk about sort of giving witnesses that time, you can't just, this isn't just like the week before trial starts, I'm going to sit down with them and practice questions, right? Like you've got it's a lot more time than you would expect.
Yeah, it's well in advance, and it's during trial, right? I mean, the preparation continues during trial. If you're defending the case, right, the plaintiff's presenting their case, and you're in court all day, and then maybe in the evenings you're continuing to prep your witnesses and getting them ready for when it's your turn. I think it's a lot of work, right? It's a lot of work for everyone involved, and the sooner you can get started and the more time you can set aside for it, the better.
Okay, so tip number 4 was prepare your witnesses, or to not use the word prepare in a third tip, maybe give your witnesses the time they need. Stephen, tip number 5.
Okay, tip number 5, I would say, is get ready to object. Objections at trial are some of the trickiest and most complicated issues that you'll deal with at trial. And part of the issue with objections is that if you are not doing a large number of trials, in effect, if you're not part of the criminal bar, you're not going to have a lot of opportunity to practice objections, because it's something that doesn't come up regularly in any other form of litigation. And so being very familiar with the rules of evidence, the basis of objections, if you're going to object to something being hearsay, that you're understanding the difference between an appropriate use of evidence that may not be direct evidence, but if you're not proffering it for the truth of the contents, it's fine. But if your witness is going to say, so-and-so told me this, and you're trying to use it as evidence that that thing is actually true, that it actually happened, that you have hearsay problems, Brown and Dunn objections, that we could have a whole series of podcasts on Evidence Act or evidence objections, and just making sure that you're ready for it, that you are in fact making the objections, that you're not sitting there passively, so that you're keeping improper evidence out. And if people are objecting to your evidence, that you're appropriately responding and making sure you're ready to defend your evidence, so that evidence you need to get in isn't getting excluded.
Yeah, or pivot, right? Depending on what, maybe the objection's fair, right? But if you don't know the potential objections and the sort of evidence and where you think they might come up, you'll be caught off your feet.
Well, Ted, it sounds like we might have a whole episode here on objections. So listeners, send us a message if you want us to do a whole episode on objections, because I think Stephen just volunteered to do that.
Yeah. Tiffany, what do you think makes like a good objection where the judge sort of says, yep, fair, or an objection where the judge just like rolls their eyes and says like, stop interrupting the flow, like I'm getting sick of you? Or is there no way to tell, right? You just kind of have to take the risk.
I think if it's a valid objection, then you should be able to make the objection. Like a valid objection is a good objection. I just think you do need to read your judge, right? So if you have we've received this tip from a really great colleague of ours, that if you test the waters a bit, make, the first time that there's some inappropriate use of hearsay, object and see how the judge responds, right? Does the judge say, you know what, like, I'll just deal with this later in closing submissions? Or is this judge sending a message that they don't really want to hear a bunch of objections? If so, take that hint and don't just, don't proceed to object every 5 minutes. But if the judge is receptive to it and is taking those objections seriously and is making those rulings in the moment, then, go ahead, right? But at the end of the day, if you think that there is a valid reason to object and you don't want that evidence in, then you should object. Even if your judge doesn't seem to like objections, you need to object if you think you need to object. But there is a component, I think, of reading the room and assessing how the judge is responding to the objections. Yeah.
Very, very good point. All right. Well, keeping with you, Tiffany, what is the sixth tip that you guys have for winning trials?
So my sixth tip is to consider your tone. And what I mean by this is trials are battles. To Erin's point earlier, we all love a good litigation drama, Suits, or I grew up watching Matlock. And it's tempting when you're, especially in cross-examination, to just fall into a very aggressive style, right? To want to show your client that you're tough and you're confident, et cetera. But you really do need to consider your tone. And this isn't just in examining witnesses, it's throughout the trial, because it's not always appropriate. Sometimes you'll have a witness you need to ask yourself, like, is this a sympathetic witness, right? Like, even though you might see this witness as the bad guy, even if you're trying to prove that this person did something wrong, if they're going to come across on, it's like some cute little old man who's dedicated their life to doing good things, but has done something wrong, that's a little bit different than someone who's spent their life being a weasel, right? And so you need to think about how you approach the witness, because sometimes if you're overly aggressive when it's inappropriate to be so, the judge isn't going to like that. But on the flip side, you're going to have witnesses that you need to be more assertive with. So for instance, if you had a witness at discovery who wasn't answering questions or was evasive or maybe was a bit argumentative with you, think about that and have that inform your strategy, right? If you want to show that this person's a hothead and that they have a tendency to blow up, I've done a lot of wrongful dismissal cases and people who have been terminated because they have really bad workplace behavior. And sometimes it's kind of fun and also effective to get those people going on the stand and show, like, look how easy this person is to, look how quickly this person is yelling at me. Look how easy it is to get them going, because it sends a strong message to the judge. If they're behaving like this on the stand, what are they like in the workplace, for instance? So you got to just read the room again and consider what's going to work best for that particular witness.
So my view is you have to be varying. You can't, it's not a one size fits all kind of approach. And trials and cross-examination, they're a bit theatrical, right? You kind of have to step into a role a little bit. It's not the same as sort of everyday speech. And so as part of that theatrics, you're adjusting what you're doing for whatever the scene is you're laying out. So if the witness is somebody who you want to get to agree with you, and frankly, who the judge is going to potentially see as credible, and you're not taking an aggressive posture, it doesn't fit the scene for you then to go in and be hard-hitting. You should never raise your voice, but more pointed with them, versus a witness who you're trying to show as somebody unreasonable, who you're going to have those pointed questions with, where you're going to take an aggressive tone. It what fits the theory of your case, what fits the scene that you're trying to lay out for the trier of fact.
Okay. So tip 6, consider your tone. Stephen, what is tip 7?
So tip number 7 is more isn't always better. And what I mean by that is, when you're presenting your case, you have to think about what the judge can actually reasonably grapple with. What are the highlights of the case? What are the key legal issues? And if you're going into your case saying there are 8 issues for you to decide, you're probably in trouble. It's no judge is going to be able to make a call that is required on that number of issues. What are the key facts? What are the key legal points? And if you get too into the weeds, you're wasting your time on issues that are not going to be central to the determination. You really have to think about your strategy and what are the key points you need to prove, and hammer those home. What are the key things in dispute, and hammer those home, and not go issue after issue after issue. So you might be able to identify 8 legal issues in your case, but then you have to think about those 8 and say, really, are all of these critical? Can I pick 4 of these that I'm going to anchor my case around and present my case around, and show a bit of judgment and strategy in what I'm going to present to the judge?
And I think it probably, to a certain extent, goes back to the earlier tip on preparation, right? Because part of really honing in on like the key legal issue is having spent all of that time meticulously analyzing the legal issues and the evidence and really distilling it down to like the major point, right?
I mean, you have sort of called me out on a little bit, and I'll admit, basically all my tips are a form of preparation. I started with it's going to be a constant theme throughout. It's a fair comment, but there's different kinds of preparation.
Sometimes, like, preparing really well, you know the case so well, so you know all of the facts, and it's really tempting to just want to share it all. Know your case, know it really well, know all of the evidence, but then really exercise some restraint and ask yourself, like, what does the judge want to hear? The judge doesn't want to hear it all. They want a story that's sort of easy to understand, and they want to know the key facts, the key evidence, and you have to exercise that restraint, and it might mean leaving out some stuff.
So, Tiffany, what is tip number 8 for us?
So, tip number 8 is it's okay to pause. And what I mean by this is that, and it's a tip that applies in a variety of circumstances. And what I mean is that when you're examining witnesses, when you're making oral submissions, when you're responding to questions from the judge, it's okay to pause. And this might sound obvious, but there's going to be a lot of times when a pause is going to serve you really well. And it's just taking a second to think about the answer to the judge's question before answering it. Maybe you're examining a witness and you're in a cross exam and things are going back and forth, really quickly. And the witness says something and a little light goes off on your brain and you think, I think that was a lie, or I think that that's inaccurate. Just pause for a second, turn to your colleague, get a gut check. Was that right? Look for that document that you want to put to the witness. I just think that it's because, going back to what's different about a trial versus other types of advocacy, there's something about being in the court. It is nerve-wracking. It is exciting. And I think sometimes we can just sort of get on a roll, and for whatever reason, we want to just keep going. And
silence is awkward, right?
Yeah.
We often find, especially in this big imposing room with a lot of people there, a lot of people waiting for you, we feel this natural awkwardness to having a moment of silence.
But the transcript's not going to show that pause. And I can guarantee you the pause is probably not as awkward as you think it is. And I think it's better to pause and get in the evidence that you want, elicit the admission you want, answer the question correctly, than it is to just skip by. I mean, this recent trial I was in, there was a number of lawyers, a number of really, really skilled lawyers on this trial. And I think I saw pauses used really effectively by some lawyers, and others I think should have paused. And I saw this happen a lot in cross, where the lawyer maybe wanted to put a document to the witness and they didn't have it. So they said, well, I'll come back to this later. And then they didn't.
But it's like you're in charge. You're at the podium. Everyone's going to wait. Just like this is your time. Yeah. I get it. Sometimes you might be rushed, right? But from a time perspective, but most situations, everyone's going to wait for you.
Yeah, I mean, you obviously don't want to be breaking it up too much, but yeah.
I've also seen and curious your views on this, because my experience tends to be more from tribunal hearings, for example. But what about if you think you need a couple of minutes, a longer pause to really go over your notes or consider something? What do you think about saying, I just need to consult with my colleague for a second, or just give me a moment, I'm going to check my notes? Like, is that a strategy that you recommend or that you see employed, or do you think you just sort of say nothing and do what you need to do?
Yeah, definitely. I definitely think you can do that, and you should do that. I think that that's totally normal, and you shouldn't be afraid to do that, actually. You can even, depending on the circumstances, you could even ask for a break. I mean, you have to think about you're not going to be asking for breaks every 5 minutes because you're having a moment.
because you're not prepared, right?
Yeah, because you're not prepared. That's a different situation. But most certainly during I was in a 10-week trial, and I can't tell you the number of times that someone said, just one moment, Your Honor, I just need to consult with my colleague. And I think that the people who did that did a better job than the people who didn't, in my opinion. So.
Okay, Stephen, do you want to add anything, or should we go on to hotly anticipated tip number 9?
No, I think Tiffany covered most of the ground there, so I'm happy to go to tip number 9.
Tip number 8, let me set it up, Stephen.
Sorry.
Tip number 8 was, it's okay to pause. So, Stephen, tip number 9, give it to us.
So tip number 9 is consider your alternatives. I know we're talking about preparing for trial here and trial tips, but before you go to a trial, you have to think about whether trial is actually the best way of dealing with your case. Is a different procedure or a revised procedure more appropriate? And it could be, you can have hybrid trials, for example, where instead of having examinations in chief, the parties are agreeing to affidavits in advance, and that is going to serve as examination in chief. And actually, earlier in this year, Ted and I did a bit of a road show on proposed changes to the rules of civil procedure. And then that's one of the general proposals under consideration right now, is whether, in fact, as a matter of course, you're going to start having evidence in chief in advance. rather than having the norm being witnesses giving evidence at trial. But it's something available to lawyers today, and is something that should be considered either as a time-saving mechanism, or because there may be issues that are less credibility driven where you don't really need the examinations in chief, and it allows you to streamline your hearing. But apart from the sort of the tweaks you can do to the trial itself, considering it, is there a way I can cut through the trial with a summary judgment motion? Or frankly, one of the alternatives too you have to be considering into the lead up to trial is, how is this trial going to go? And should I be recommending a settlement to my client to avoid the trial altogether? These are all factors that you have to be considering as you head towards trial. Lots of matters settle sort of at the courthouse steps, and it's because people are taking these sorts of considerations and are not just stumbling down the path towards trial or bust.
Great. Well, why don't you close this off, Tiffany? What is the 10th and final tip that you guys have for us?
So the 10th and final tip is to practice with civility. And we touched on this before, but it goes without saying that we're officers of the court. We should be carrying ourselves out in a respectful and professional manner. It's always important to try to be polite and as civil as possible with your opposing counsel. But it's not just the right thing to do, but it's also a really important thing to do, because I think it really increases your credibility with the judge. The judge doesn't want to see lawyers bickering and engaging in sharp practice. Judges want the parties to work together as much as they can to move the trial forward in an efficient way. And I think that it serves you well to do that, right? So obviously you're going to put up a fight when you need to put up a fight. You're not going to just, I'm not talking about being a pushover, but I do think that it's important that you're demonstrating that you are a reasonable person, and because judges trust reasonable people. And so it's actually in your client's interest to come across as a reasonable and professional person. So
it's part of the advocacy, right?
Yeah, exactly.
It's part of the representation. No, that's a really, really good point.
Yeah. And even if you are, taking a more aggressive position, there's still a way that you can do that civilly, right? It's all about going to the earlier point, the tone that you're using, how respectful you're being in your communications. You can hold the line and take a firm position for your client while doing so in a very respectful, civil manner as an officer of the court, right? So not to confuse those two concepts, I guess.
And you can explain to your client why you're doing those things too, right? Like I think a lot of it is about client management. So a lot of times at the beginning of the day at trial, you'll have some housekeeping items, right? Like maybe you and opposing counsel have talked about schedule for witnesses, or you've talked about there's a motion in the trial, and you've talked about timelines for producing or giving submissions or something like that. And you kind of are getting up there, and there's sort of a friendly back conversation that's happening. And I think that just explaining to your client why you're talking to their side, what you're talking to them about, and why it's important that you appear reasonable, why it's important that you are cooperative on certain things. And then your client they'll feel comfortable with that, and they'll trust your judgment. So I think it's just part of the client management. And because we all learn about trials mostly from watching TV,
which, as we've established, is not reflective of.
It's not reflective of reality a lot of the time. Yeah.
Okay, well, thank you both for these fantastic tips. Erin and I have learned a lot, and I think our listeners have too.
It's our pleasure.
Thanks for having us.
That was a really interesting discussion. Did you learn anything from those 10 tips that you might employ in your next trial?
You know what? I'm going to take to heart what Tiffany said about not being afraid to pause and just sort of like own the moment. You're running a cross-examination or you're making submissions. If something happens, stop, take the time. People will wait, but don't just let the momentum drive you forward. Yeah, definitely.
No, I think that's a good one.
I don't know. What about you? Is there anything that you learned that maybe you didn't know before?
I think it's more just reflecting on Stephen's discussion of considering alternatives to trial or different types of trial and hybrids. I was actually making some notes on some potential strategies that I want to consider for some upcoming matters. So I think those were just really good practical reminders that there is flexibility baked into these processes, and some of that early strategic preparation and thinking about different alternatives and models to trial is something we should all be doing.
Awesome. Good stuff. Listeners, I hope you enjoyed this episode with Stephen Taylor and Tiffany O'Hearn Davies. Feel free to subscribe to Disputed wherever you get your podcasts.